जय हिंद, जय भारत, वाहिगुरु जी का खालसा, वाहिगुरु जी की फतेह. Today we have entered the 73rd Republic Day, 26th January 2022. I select some topics every time for discussion on Independence Day and Republic Day in national interest. Today I select a topic which is concerning the masses and the courts of law, particularly the higher courts, the High Court as well as the Supreme Court of India. The Constitution of India provides for remedies under Article 226, 227 with the High Courts and Article 32 with the Supreme Court of India. Unfortunately, what we see today, specifically by the Supreme Court, stated with due respects, that Supreme Court under Article 32 takes lot of time and lot of exception to interfere. According to me, this approach of the Supreme Court in today's times needs a complete rectification. Frankly speaking, the Constitution of India that we made in 1950 was as regards those circumstances prevailing at that time. The population was less, pretty less. The government today is, say, 70% of the litigations in the courts are due to the government non-performance. And the remedies lie under Article 32 of the Constitution of India if it violates the fundamental rights, that is Article 14 to Article 51. And with the High Court if it pertains to legal rights. This situation was not so grim until 1960s and 1970s, where government wrong used to be there, but not to such an extent, not to such a frequent extent. Today, government wrong has become a part and parcel of everybody's life. Many people have even started let go of government wrongs, of errors, of omissions and commissions. The three most corrupt departments in India today, following which there are some others also. Corrupt does not necessarily mean taking money. Taking money is only a part of corruption. Corruption can be due to arbitrary action also. Any arbitrary action can also be regarded as a corrupt practice. Corruption starts with the mind. Mind then takes the form of action. And all actions are not corrupt, but some actions are corrupt. Some actions are basically malfunctioning. Disobeying orders of the court, disobeying guidelines, disobeying law, taking advantage where law is weak. So what has happened today is 70% of the litigations in the High Court and the Supreme Court, if you go to see, are due to government wrong. Now, High Courts, when we go to Article 226, High Courts also many a time say, we have to use Article 226 with exception. Supreme Court in Article 32 says, the higher the power, the more careful the Supreme Court has to be. But what both these courts of law, the High Court as well as the Supreme Court, with respects, without meaning any contempt, forget is that this constitution was made in 1949-1950, where the government wrong was very less. It was hardly anything. It was 20% of what wrong is being done today. So one cannot apply the concept of exceptional jurisdiction under Article 226 and Article 32 because now the situation is that the government, whether the state government or the central government, they perform badly, as a result of which people are not satisfied. The fundamental rights in and out nowadays start being violated. An example of the fundamental right of today being violated is the mobile phone itself. The phones that we carry, they invade into all the privacy. Now, with this kind of a situation, if a person goes to the Supreme Court without being a victim, but he goes in larger interest by way of a PIL or by way of Article 32, I don't see any reason why in today's terms Article 32 should not be used by the Supreme Court. And same applies to Article 226 also. Many times in PIL, we find High Court saying, no, he's personally interested. See, unless a person is personally aggrieved, he will not be able to point out at the larger damage that is being done. So that personal interest does not become personal interest. He's a victim of that particular cause. So in my respectful appeal to the High Court and the Supreme Court is that one has to discard this concept of exceptional jurisdiction and be generous in indulging under Article 32 and Article 226. The three, I had forgotten to continue in between, the three departments which are highly erroneous or corrupt or malfunctioning. The first starts with the municipal bodies. The municipal bodies would be the municipal corporations of all over India, which includes the Gram Panchayat. Then comes the police, and then comes the revenue. Revenue, with slow and steady onlineization, the corruption levels have reduced. Now, with these kind of departments which interact with people daily, and daily there are going to be government wrongs, can we have the concept of exceptional jurisdiction under Article 32 and Article 226 prevailing anymore? With respects, I may say that the Constitution of India itself would require some amount of amendment. And if the Constitution of India is not amending itself, it does not prevent the High Court and the Supreme Court to use its inherent powers when the rise of the cases itself is so high. There is no question of exception. One has to discard that concept. With this message to the higher judiciary and to the masses, to the law brethren, I may say that I may appeal to the higher courts of India to discard the concept of exceptional jurisdiction and show indulgence in befitting cases. Jai Hind, Jai Bharat, Vaheguru Ji Ka Khalsa, Vaheguru Ji Ki Fateh.